Hello everyone, this is Aparna Bhat. Welcome to Unacademy Judiciary YouTube channel. So we are doing a new kind of analysis for Kerala. This is the first time we are conducting Kerala question paper analysis series. So totally there would be about 7 to 8 question papers where we are understanding how the question paper was conducted, how the examination pattern was conducted, and similarly what are we going to discuss the questions, how are we going to answer them. So regarding all these things we are going to see. So this is regarding the 2022 question paper today's class, and this week, completely this week, we would be discussing all our other classes like 2020 question paper, 2019, 2018, so 2022 was there, after that 2020 was there, then 2019 was there. So likewise we have already scheduled, so you can check those links provided in this Unacademy Judiciary website. So in this 1 hour or 1.5 hour session, we are just going to discuss the important questions which have been asked in the examination with reference to the key answers provided. So the key answers are taken from the High Court website itself, the High Court of Kerala itself. So we are taking that, and along with that we are discussing that. So in some of the question papers, some questions are deleted. Okay, so some questions are deleted, so that I am going to skip, but still some answers, if it is proper due to some other reasons, if it got deleted, that one we are going to discuss. But ultimately what we are going to see is what is the question and some of the reasons or explanations for that particular question. Okay, so without any delay, let us begin with the question paper for today's class. See here, Kerala paper consists of 3 parts actually. Okay, so if we check this, you can see in the screen. So totally for 2.5 hour duration, you are having the question paper, and the maximum marks is for 200. And negative, totally 100 objective questions are there, but even for wrong answers, negative answers are provided, are given. That's why you must be very, very careful while answering the answers. So if we check the 2022 question paper, so totally there are 3 parts, part A, part B and part C. Part A is with reference to our civil law, part B is with reference to criminal law, and part 3 is with reference to constitution and other general reasonings. Okay, so okay. See what happened in this 2022 question paper was about 8 to 10 questions are deleted, and for some answers even alternative answers are provided, either A or B or C. So with reference to that some answers are there. So let us understand them properly. Okay, so without any delay, let us go to the first question. Okay, the first question: under section 146 of the Contract Act, the co-sureties are liable to contribute A equally, B unequally, C according to capacity, and D neither A or B or C. So what is the answer here? Hello Aarti. Okay, please try to answer in the chat box if possible. Yes, what is the answer here? Yeah, it is A equally, that is according to section, which section? It is section 146 of Indian Contract Act, Yes, the next question: under the Specific Relief Act, a suit for recovery can be filed only in respect of mobile property, B in respect of both mobile and immobile property, C only in respect of immobile property, and D neither the movable or immovable property. Yes, what is the correct answer here? Second question. It is B, that is Specific Relief Act, recovery for possession of the property can be filed for both movable and immobile property. The sections are from section 5 and 6 for immovable property, and section 7 and 8 are with respect to movable property, right? Yes, next one. Section third question, section 53A of the Transfer of Property Act deals with A. Doctrine of election, B. Specific performance, C. Part performance of the contract, and D. Fraudulent transfer. So these are all the different kinds of doctrines which are provided under the Act. So what does section 53A, what does it deal with? Section 53A provides for the part performance of the contract. Okay, so this is a kind of a defense which a defendant can avail of. He can say that I have obtained the performance provided the agreement are registered and provided the agreement are if it's in writing, then he can claim the part performance of the contract. This can be used as a shield but not as a sword. That's a common statement which we can see. Okay. Next one, fourth one. A check is a dash drawn upon a specified banker and it is payable on demand. So what kind of check it is? Whether check is a bill of exchange, whether it's hundi, whether it's a promissory note, or whether it is none of the above. What is it? We can say that a check is a kind of a bill of exchange. It is provided under section 6 of Negotiable Instruments Act. It is one of the kind of the bill of exchange only where the banker is a common party always. One of the drawer is the bank. Next one, this question was deleted. Okay, in the question paper where final answer was given, this question was deleted, but in the provisional answer, so section 25 of the Limitation Act deals with, actually section 25 deals with which of the following provisions? A. Acquisition of easement by prescription, B. Special exception, C. Effect of acknowledgement in writing, and D. Continuing breaches and torts. What is it? It is actually A. A is the correct answer. Fifth, though section 25 it deals with the acquisition of easements by prescription, by way of the prescription. Next, sixth question. Which section of the Kerela Buildings Lease and Rent Control Act interdicts the tenant from contesting the application or preferring an appeal under section 18? A. Section 11 subsection 2, B. Section 5, and C. Section 12 subsection 1, and D. None of the above. So this section, Kerala Buildings Lease and Rent Control Act, it says that the tenant from contesting the application or preferring an appeal under section 18. It is none other than C. Section 12 subsection 1. Okay. Next one, seventh question. Even this question was deleted. However, what is the answer for this? Section 14 of the Limitation Act deals with A. Effect of fraud or mistake, B. Extension of prescribed time in certain cases, C. Exclusion of time taken for proceeding bona fide before a court without jurisdiction, and D. All of the above. Section 14. Actually, if a person has spent some time in prosecuting a bona fide case, then that time can be excluded. So that is provided under section 14. C, we can say the answer is C. The provisional answers were given as this one. Next one, eighth question. Pari passu distribution means. What do we mean by pari passu distribution? Equal distribution, B. Rateable distribution, C. Partition by metes and bounds, and D. None of the above. Pari passu. It is? Yes. Yes, Aarti, exactly. Hi, Athira. Okay, now I saw your name, Athira. It is A. Equal distribution. Pari passu amounts to the equal distribution. That's the meaning of this. Next one, ninth question. Which is not correct about the promissory note? A. It contains a conditional undertaking. B. It contains the amount mentioned on it. C. It's an instrument in writing. And D. It is signed by the maker. Which is not. So, what actually is a promissory note? It is defined under section 4 of the Negotiable Instrument Act. So, when that is the case, it is an unconditional undertaking. So, whereas what has been given here, this has been given as a conditional undertaking. So, this is wrong, but other statements are true. It contains the amount mentioned on it. It is an instrument in writing, and it is also signed by the maker. All statements are true, whereas only this is a wrong one. Hence, this is the incorrect statement. That's why correct answer for section 9. Next question, 10th question. As per order 13 rule 9, the person entitled to receive back a document produced in a suit is dash. A. Only a party to the suit. B. Plaintiff. C. Defendant. And D. Person who produced the document, whether a party or not. Yes, Ati, it is unconditional. Exactly. Okay, so what does this order 13 say about? It speaks regarding the returning of the documents, back. Order 13 is with respect to the production, admission of the documents, return of the documents, admission of the documents, receiving the documents. So many options are there. So, when such things are there, according to 39, which is, so whose document can the court order to give it back? Who can take the documents in return? So, it is D, the person who produced the document, whether he is a party or not. Okay. This is the correct statement here. Next one, 11th question. Actually, the options are wrong. That's why the question got deleted. Okay. So, I am not going to discuss this because in the final key answers which have been provided, it is the question itself got deleted. But in provisional answer, they had given this A as the correct answer. So, for better understanding, let us not discuss this question. As in final key answers provided by the High Court of Karnataka, High Court of Kerala website only, it got deleted. They have deleted the question. Next one, 12th question. Under section 6(2)(a) of the Specific Relief Act, no suit shall be brought after the expiry of a period of dash from the date of disposition. A. 6 months, B. 1 year, C. 2 years, and D. 3 years. Yes. So, what is the answer for the 12th question? It is 6 months. As per which section? Section 6(2)(a) of Specific Relief Act. Okay. So, there is a time limit, and even this, so section 6 is based on the possessory title. That is why even it cannot be filed against the government, right? Yes. So, the next question, 13th. A suit posted for hearing can be adjourned by the court only a maximum of dash times at the instance of a party. So, for how many times, for how many maximum number of times a suit can be posted, like on adjournments can be given. So, this is a question under order 17 actually, order 17 rule 1. So, maximum 3 number of times, that is the maximum number of times where a suit can be posted on the adjournment. Next one, 14th question. What is the remedy provided against an order passed at the execution stage in a rent control petition? A. Appeal, B. Revision, C. Writ petition, and D. None of the above. What is the remedy for this? When order is passed in the execution stage, it is the revision. Okay, B is the correct answer. Next one, 15th question. A suit for possession under section 5 of the Specific Relief Act can be filed within A 3 years, B 12 years, C 5 years and D 9 years. A suit for possession. So, what is the limitation period for this? So, this is for any suit for possession, normally 12 years time is there under Article 65 of the Limitation Act. Next one, 16th question. So, even this question got deleted. So, I am not going to discuss this. This is based on the Indian Partnership Act, but in the provisional answers they had given as this as the answer, but in the final list it got deleted. Okay. So, let us not discuss the 16th question because it may give wrong interpretations. Let us directly go to 17th question. An inchoate instrument. What do we mean by an inchoate instrument? It is an incomplete instrument, it is an instrument presented beyond time, C an illegible instrument and D none of the above. Yes, Adhira, you are also answering. Yes. What do you mean by an inchoate instrument? Yes, it is an incomplete instrument. We can find this under Negotiable Instrument Act. So, even if the instrument is incomplete also, if the person has given it, it has certain value. So, that idea it conveys. Okay, the other person can fill and he can give for the encashment of that instrument. And the next one, 18th question. So, even this got deleted. So, if we find there are about 8 to 9 questions which got deleted. So, the entire 100 questions question paper gets reduced to 90 questions when we discuss this question paper, and for some they have given alternate answers like B or C, C or D they have given. So, this was because some it got deleted because maybe due to some options are wrong or some questions could be wrong, because Limitation Act it says from the date of the instrument. So, likewise there some confusions could arise. Okay. So, even I am not going to discuss this, this was based on the promissory note. So, but just you can check such questions based on that. So, suit on promissory note we can say under Article 34, Article 35 and all are there. Actually it is 3 years, but the answers may not be suitable to this question. That is why it got deleted. But please refer to Article 34, Article 35 of Negotiable Instrument. Next one, 19th question. The rule against perpetuity is contained in A. Section 32 of the Partnership Act, B. Section 62 of the Contract Act, C. Section 14 of the Transfer of Property Act and D. Section 6 of the Specific Relief Act. So, what is the rule against perpetuity? It is a kind of a rule given in the Transfer of Property Act with respect to unborn persons. So, we have section 13 also, we have section 14 also. So, among these sections it is C, that is section 14 of the Transfer of Property Act. Yes, Aarti, yeah, I can see that you are answering, good. Next one, 20th question. Section 114 and Order 47 Rule 1 of Code of Civil Procedure pertains to the filing of A. Appeal, B. Revision, C. Review and none of the above. So, we have the second stage proceedings after suit. The remedial measures could be you can go for an appeal or review, revision, reference. So, these are different modes, but what does this section 114 and Order 47, how does it relate to? It is nothing but review, 114 and Order 47 Rule 1. Next one, 21st question. Which of the following tests are to be applied in cases where the plea of bar of suit under order to rule 2 is raised? So this is a very important kind of defense. How constructive res judicata is there. Likewise, even order to rule 2 is there. So whether the cause of action in the previous suit and that in the subsequent suit are identical. B. Whether the relief claimed in the subsequent suit could have been given in the previous suit on the basis of the pleading filed in that suit. C. Whether the plaintiff omitted to sue for a particular relief on the cause of action disclosed in the previous suit. And D. All of the above. So what is the answer here? You can claim all these pleas of bar of suit in these cases. So always there is a saying that if you are filing a suit, whatever actions are there from a particular cause of action, whatever remedy you want to take from that cause of action, that has to be included in the suit. You cannot splitting of claims, splitting of remedies is not permitted. That's why, what is the answer here? It is all of the above. Okay, it includes all these tests have to be applied, like whether the cause of action in the previous suit, the subsequent suit are identical, so it relates to the cause of action, and whether the relief claimed in the subsequent could have been given in the previous suit on the basis of the pleading filed in that suit, and whether the plaintiff omitted to sue for a particular relief on the cause of action disclosed in the previous suit. Please see the test. These are the 3 tests which are applicable for the application of order to rule 2 under Code of Civil Procedure. Right. Next one, 22nd question. Where a promissory note is payable by installments and 2 or more installments have become due and the holder of the note sues only for one of the installments and omits to sue for the other installment. A. He can sue for the other installments later. B. He cannot sue for the other installments. C. Either A or B. And D. None of the above. Under which question is this? Under which provision? This refers to order to rule 2 only. So if you could have claimed this relief earlier, then you cannot split that relief and you can claim in the next suit. That's why with respect to installments, he was supposed to claim it earlier only, not in the next. So that's why B is the correct answer. He cannot sue for the other installments. 23rd question. Which provision of the Code of Civil Procedure deals with the transfer of a decree? A. Section 52, B. Section 39, C. Section 41 and D. Section 151. This is a very important question with respect to the execution. Whenever you have to carry out execution in some other court, then the decree needs to be transferred. Transfer of suit, we refer it under section 22, 23, 24, 25. Whereas this is the question of transfer of a decree. That's why the correct answer is B, that is section 39. Next one, 24th. To calculate the maturity date of a negotiable instrument, the drawing date, B, should you include the drawing date to calculate the maturity date of a negotiable instrument? So A included, B considered, C excluded and D then none of the above. It is okay. Vinny has answered. Vinny, Aarti. Yes, it is C. That date has to be excluded. Next, 25th question. According to the provisions of the Transfer of the Property Act, the easements can be transferred, cannot be transferred apart from the dominant heritage and D, none of the above. Is it visible? Should I zoom it a bit? Okay, this is the question under Transfer of Property Act, section 6. Which properties are transferable, which properties cannot be transferred. So that's why it is C. It cannot be transferred apart from the dominant heritage. Next one, 26th question. The doctrine of lis pendens is applicable to A. Movable and immobile properties, B. Partial and absolute transfers, C. Specified and unspecified properties, and D. All of the above, all of these. Okay, it's visible now. Okay, fine. The doctrine of lis pendens, you cannot transfer a property in the pendency of the litigation, in the pendency of the suit. Even if you transfer it, the parties are bound by such decision. This is the rule which we can find under section 52 of the Transfer of Property Act. So this is applicable to all kind of transfers, partial or absolute. Absolute transfers example is sale and gift, whereas partial transfers is the example for mortgage, lease. These are all the examples of the partial transfers. Next one, 27th. Novation means, what do we mean by novations? A. Substitution of one agreement with another, B. Cancellation of agreement, C. Withdrawal from an agreement, and D. Expiry of an agreement. Novation is a concept, novation, alteration of a contract, rescission of the contract. These are all the provisions under our Indian Contract Act. Yes, it is A. Substitution of one agreement with another. That is section 62 of Indian Contract Act. 28th question. The limitation prescribed for filing application to implead the legal representatives of a deceased defendant or respondent is A. 30 days from the date of the defendant or respondent. Okay, sorry, this question got deleted. Actually, it is 90 days, but the answers were given as 30 days. So this question got deleted. How many days do you require to implead the legal representatives of a deceased defendant? It was supposed to be 90 days. Then to set aside that abatement, if they do not implead the legal representatives, and due to which the suit gets abated, to set aside the abatement, you have time to file setting aside application 60 days. Otherwise, it is 90 days. So let's not discuss more on this question as it already got deleted. Next, 29th question. Under section 89 of CPC, the court shall formulate the terms of settlement and give them to the parties for their observation, and after receiving the observation of the parties, the court may reformulate the terms of probable settlement and send them for A. Arbitration, B. Mediation, C. Settlement before Lok Adalat, and D. All of the above. So 29th question. Section 89 provides for the alternative dispute resolution mechanism. That's why all of these are different methods of ADR system. And even we have reference under order 10 rule 1A, 1B, 1C also. So please refer those also with respect to ADR, because a court has to refer them, section 89 and order 10, 1A, 1B and 1C. Next one, 30th question. Yes, please read this. This is based on the place of suing. Babu entered into a sale agreement with Thomas. So Babu and Thomas entered into a sale agreement for purchase of 5 cents of land belonging to Thomas, situated at Ernakulam. The agreement was executed and advance sale consideration paid at Thiruvananthapuram, where Babu is residing. Thomas having failed to execute the sale deed, in spite of Babu being ready and willing to pay the balance sale consideration, Babu can institute a suit for specific performance of the agreement at A. Thiruvananthapuram, B. Ernakulam, C. where Thomas is residing, and D. all of the above. This is a question which is related to the suit relating to the immovable property. So when there is a specific performance of the agreement, this comes under section 16 suits. Suit relating to immovable property, suit relating to reliefs relating to immovable property. That's why it has to be filed where immovable property is situated, and in this case immovable property is situated in Ernakulam district. That's why B is the correct answer. 31st question. Rajan had let out his shop room to Venu on rent. Venu clandestinely sublet a portion of the room to Gopi. On coming to know about this, Rajan caused a lawyer notice to Venu under section 11 subsection 4 of the Building Lease and Rent Control Act, but omitted to mention Gopi's name. Will the omission be fatal when Rajan files a rent control petition for evicting Venu alleging a sublease? So sublease is a ground for filing eviction petition for the landlord. In such a case, when Gopi's name has been left out, if his name has not been given, will it be a fatal to this whatever suit Rajan has filed? So A fatal, B not fatal, C curable, and D none of the above. It is B, not fatal. Okay, that's not necessary. Even if subleased person is there, even if his name is not included, that will not be very serious fact in deciding rent control petition. 32nd question. Constructive res judicata is contained in explanation 3 to section 11, B explanation 4 to section 11, C explanation 6 to section 11, and D explanation 7 to section 11. What do you mean by constructive res judicata? This is also known as might and ought principle. That's why you need to properly understand the entire explanations of res judicata. Might and ought principle. Yes, it is B, that is explanation 4 to section 11. This is commonly asked question, explanation 4 to section 11. Next, 33rd question. Which among the following is not essential in relation to transfer of property to an infirm person under the Transfer of Property Act? A life interest in favor of one or more living person. B, the unborn person should come into existence before the expiry of prior life interest. See, the remaining right after creation of life interest should be transferred to unborn person. D, the unborn person should be a descendant of the original transferor. A very important question under section 13 of TP Act. What is the answer here? See, always when a person transfers a property to unborn person, he cannot transfer it directly. That's why in between a life interest has to be created for a living person. Okay, and before his interest ceases, unborn person should have born, and whatever remaining interest is there in this property, life interest has been given, the remaining interest should be vested in the unborn person absolutely. That's why all these three statements are true, but there is no rule that he should be descendant of the original transferor. There is no such rule, and this is the proper answer. D is the correct answer. 33D. Next, 34th question. Which among the following is not a new provision introduced in the Specific Relief Act of 2018 amendment? A, time limit for disposal of cases under the Act. B, special court for trials of suits under the Specific Relief Act. C, provision for substituted performance, and D, none of the above. What is the answer here? It is special code for trial of suits under the Specific Relief Act. B. But actually the answer was given like this in the key answer. This is 20B. Section 20A, 20B, 20C all were substituted, but actually this was section 20 was already there, but it was like what we can say, it got a new name. Earlier it was known as the discretion of the party. So I found this question a bit doubtful, okay, because section 20 was already there, provision this was substituted, whereas 20A, 20B, 20C were all added. Next, 35th question. In which among the following mortgages a personal undertaking by the mortgagor is essential? A. Usufructuary mortgage, B. English mortgage, C. Mortgage by conditional sale, and D. None of the above. So, in this mortgagor, a personal undertaking by the mortgagor is essential. In which kind? It is, yes, Aarti, it is English mortgage. In the case of English mortgage, only in case of English mortgage and personal mortgage. In case of personal mortgage, the mortgagor will undertake a personal undertaking. Okay, so it is section 58. Section 58 deals with the definition of mortgage and different 6 kinds of mortgages. So please refer that. I think 58E, I guess. English mortgage is the correct answer here. 36th question. Which among the following is the procedure for transfer of an actionable claim? So how do you transfer the actionable claim? So A. Delivery of possession, B. By a formal declaration, C. By an instrument in writing signed by the transferor or agent, and D. By an instrument in writing signed by both the transferor and the transferee and attested by 2 witnesses. What's the correct answer here? Transfer of an actionable claim. It is as per section 130, Winnie, it is C. Only you require the writing signed by the transferor or agent. You do not require the attestation. Only in mortgage and gift attestation is required. Otherwise, in even registration is not required here, only writing by an instrument in writing signed by the transferor or agent. That is sufficient. Next, 37 question. Agreement in restraint of trade is A. Voidable, B. Void, C. Illegal, and D. None of the above. This is the question under Indian Contract Act. So 37. This is example of this void. Hello Mir Yasra, good evening. Yes, it is section 27. Section 27 of the Indian Contract Act. Next, 38th question. How is gift of immobile property affected? A. By delivery of possession by a registered instrument if value is more than ₹100 or and otherwise by transfer of possession. B. C. By registered document attested by 2 witnesses, and D. By an oral transfer. What is the answer here? Because gift of immovable property has also been provided. It can be done by way of delivery. But in the case of gift of immovable property, irrespective of the amount, whatever, like there is no such more than 100, less than 100, irrespective of whatever amount, you require registration along with attestation by 2 witnesses. So C is the correct answer. Next one, 39th question. Feeding the grant by estoppel is incorporated in dash of the Transfer of Property Act. A very simple question. A section 43, B section 41, C section 35 and D section 21. Section 41 and 43, those are all the doctrines regarding doctrine of holding over. So someone else is the owner or due to some ostensible owner is there. Okay, likewise we have based on those principles only section 43 is there. So section 43 is the correct answer. Feeding the grant by estoppel. Yes, Aarti, Mir, Esra. It is section 43. The next question. Yes. Which among the following sections of the TP Act govern the transfer of property to unborn person? A section 12 and 13, B section 13, C section 13 and 14 and D section 9, 10 and 13. Yes. Sorry for that. Okay, see here what has happened was for these 2 answers have been provided. Okay, because as section 13 is also there, along with 14 is also there. So in the key answers, as the options provides, it has both the answers. So B is also correct, C is also correct. Both are correct. So this was about part A. So 40 questions were there in part A, mostly with reference to our civil law. Then comes part B. Okay. So where a magistrate has imposed a substantive sentence on the accused, a sentence of imprisonment in default of fine shall not exceed dash of the term of sentence which magistrate is competent to impose as punishment. A 1/2, B 1/3, C 1/4 and D none of the above. When there is a substantive sentence and what is the default of fine? Default of fine, how much imprisonment can be given? This is a question under section 30 of CRPC. So it is 1/4 of the punishment. 42nd question. Which among the following sections incorporates the principle of vicarious liability in criminal jurisprudence? A section 120B, B section 120A of IPC, C section 149 IPC and D section 34 of IPC. Vicarious liability is a person is liable for the acts of others. So even here both the options were given. Options were given as D also, C also. So section 34 is with respect to common intention, 149 is with respect to prosecution of a common object. So that's why section 149 is also correct. So section 34 is also correct. Okay. Next 43rd question. In the trial of a criminal case, the question touching the relevant matter in issue is put to the witness. He refuses to answer, contending that the answer will incriminate him. Can he be compelled to give evidence? If so, under which provision of the law? This is a question under Indian Evidence Act. So regarding the compulsion of a witness, where if he gives the answers, it will tend him to criminal prosecution. So in such a case, can he be compelled to give evidence? So we have 2 sections with respect to that. That is B, section 132 read with section 147 of the Indian Evidence Act. Yes. Next 44th question. After the trial was over, charge was altered invoking section 216 CRPC from 1 under section 306 to 302 IPC. Thereafter, on request of the prosecutor, a surgeon who was not examined earlier was permitted by the court to be summoned. Is the court legally competent to do so? Okay, so this is regarding the alteration. So when such alteration is there, a person who was not examined earlier, can he be recalled? Can he be summoned? That's the question. So what do you all think so? 44th question. If so, under which section? Regarding alteration of charges. It is C, under section 217B, where a person can be recall of witness. When a witness can be recalled when charge is altered. Charge is altered. Next, 45th question. A bond is executed by the accused for the appearance in court. The accused failed to appear in spite of specific directions. What should be the next step taken by the court under section 446 CRPC? This is regarding the bond. Even after the bond is executed, he is not appearing, he is failing to appear. What is the consequence for failure to appear? A. Issue show cause as to why bail bond shall not be forfeited. B. Record satisfaction regarding forfeiture and call upon the person to pay penalty or to show cause why it shall not be paid. C. Cancel the bail bond, impose penalty on the sureties for such amount not exceeding the bond amount. And D. None of the above. It is, first of all, he has to record satisfaction regarding forfeiture. Then he should call upon the person to pay penalty and to show cause why it shall not be paid. It is B. B is the correct answer as per section 446 CRPC. Next one, 46th question. In which among the following oral admission as to the contents of documents is irrelevant? Regarding the document, because for contents has to be proved by the documentary evidence itself. But when it comes to the oral admissions, oral admission, not just oral evidence, but oral admission as to the contents of the documents, a party proposing is able to show that he is entitled to give secondary evidence under the rules. B. If the genuineness of the document in question is admitted. C. If the document in question is an electronic document. And D. None of the above. It is, okay, Mir, Yasra, he is saying B, and Vinny, you are saying it as A. Actually, it is A. What is the section for this? Section 22. Section 22 of Indian Evidence Act. If party proposing is able to show that he is entitled to give secondary evidence under the rules. Okay. Next one, 47 question. Which among the following is not correct under section 34 of IPC? A. Prior meeting of mind is essential. B. Commission of a criminal act by one or more persons among the group in furtherance of criminal intention of all. C. Each of the person need not commit any individual overt act. And D. Each of the above persons accused of common intention should be present at the time of the commission of the offence. So, which is not correct? As per section 34, it is okay. Mir, you are saying for 45th question? Yes, it is for 45th. Okay, okay. And here 47th. Actually, for 47th, I feel it as D. But the key answer were provided as A. Prior meeting of mind is essential. Okay. So, all the persons need not be present at the time of the commission of the offence. So, some doubts are there with respect to section 47. Yeah, it is section 34th question, no? So, that is why. But in final key answers, they have mentioned it as A. So, let us reserve this question. Next, 48th question. In which among the following instances sanction under section 197 CRPC is essential? This is a question with the reference to the cognizance of the offences. So, A. So, where the accused is a public servant and the offence was done by him while he was a public servant. B. Where the accused is or was a judge or magistrate or a public servant not removable from office, say without sanction of government, is alleged to have committed offence while acting or purporting to act in discharge of his official duty. C. Where the accused is or was a public servant and is alleged to have committed offence while in service. And D. None of the above. So, what is the answer here? It is B. As per 197, if the accused is judge, magistrate, public servant, if the offence is with respect to the discharge of their official duty, then sanction from the government is necessary. This is very necessary. That is what section 197 says. B is the correct answer. 49th question. If a written complaint is submitted to a magistrate who is not competent to take cognizance of that offence, he shall direct the complaint to the proper court, B. return it for presentation to the proper court with an endorsement, C. forward the complaint to the proper court through concerned SHO and direct the complainant to that court, and D. return it for presentation before the proper court and to refer the party to the proper court. Okay. This is a question under complaint, section 201 of CRPC. When the magistrate is not competent to take cognizance, he will return it for presentation to the proper court with an endorsement. Okay, B is the correct answer. Next one, 50th question. To attract principle of estoppel, which among the following conditions must be fulfilled? A. Representation by a person to another. B. The other shall have acted upon the said representation. C. The act should have been detrimental to the interest of person who has acted. And D. All of the above. Question under section 115 of estoppel of Evidence Act, Indian Evidence Act. All the three statements should be fulfilled. That is why D is the correct answer. All of the above. 51st question. Dying declaration to be admissible, what has to be done? It must be made before a magistrate, must be made before a police officer or a doctor, may be made before any private person, and D. all of the above. So, dying declaration, section 32 of Indian Evidence Act, all of the above. It must be admissible. It can be admissible before any of these persons. Magistrate, police officer or private person also. 52nd question. Which among the following is not an essential ingredient of criminal conspiracy? Section 120B. An object to be accomplished, a plan or scheme embodying means to accomplish that object. See, an agreement or understanding between two or more persons to cooperate for accomplishment of that object. And D. Commission of an overt act, which is not an essential act. It is D. Commission of an overt act is not necessary. 53rd question. Which among the following condition is to be satisfied to enable a court to order appointment of commission to examine a witness? A. Whenever the court feels so. B. Whenever the presence of a witness cannot be easily procured without an amount of delay, expense or inconvenience. C. Whenever the court feels that the summoning of the witness may cause delay, and D. None of the above. So, when can the commission can be ordered? It is 53rd question. It is B. Whenever presence of witness cannot be easily procured without delay, expense or inconvenience. So, even in CPC also we have, CRPC also we have the provision, but this is with reference to our CRPC. Okay. 54th question. Which among the, in which of the following the court can order cost to be paid by the accused to the complainant? Under section 359 CRPC, when a person is convicted on a complaint of a non-cognizable offence filed by the complainant. B. Under section 358 CRPC, when a person is groundlessly arrested. C. When compensation is ordered under section 357 of CRPC, and D. None of the above. It is A. Under section 359 CRPC, on this ground court can order costs. Next, 55th question. In which among the following circumstances can the court permit indecent and scandalous questions to be put to witnesses? A. If it relates to the character of the witnesses. B. If it relates to the fact and issue. C. If it relates to previous conduct of the witnesses. And D. Court cannot permit indecent and scandalous questions. 55. Now we have one section with respect to section 151 of Indian Evidence Act. If it relates to the fact in issue, then the court cannot avoid that. It cannot, suppose the question is regarding a defamation or something. 56th question. Which among the following cannot be a method of impeaching the credit of witnesses? A. Through the oral evidence of any other witness. B. Through the evidence of persons who know that the witness is not creditworthy. C. By proof that witness has been bribed. And D. By producing previous contradicting statement of witnesses. How the credit of the witness can't be impeached? So, you cannot obtain the evidence of other witnesses. Okay. So, through the oral evidence of the other witnesses, a witness credit cannot be impeached. Next, 57th question, section 34 of IPC is a rule of evidence, a substantive offence, and coet offence, and D. None of the above. Section 34 of IPC relates to, it is a rule of evidence rather than an offence. Offence is section 149, whereas 34 IPC is just a rule of evidence. How, what can be proved against whom? 58th question. Under Indian Penal Code, illegal signifies A. Everything which is an offence. B. Everything prohibited by law. Everything which furnishes ground for civil action, and D. All of the above. We have section 43 of IPC which defines what is illegal. It includes all these things. Even any ground which is furnishing for civil action, hence D. All of the above is the correct. Next, 59th question. Which among the following is true for dying declaration? Dying declaration cannot be used as the sole basis of conviction. Dying declaration, unless corroborated, cannot be read as sole basis for conviction. Dying declaration which is cryptic must be disregarded. D. When witnesses affirm that deceased was not in a fit state to make declaration, medical opinion cannot prevail. So even I find some doubts in this question, okay, regarding the options. The key answers were provided as this, the final key answer. D was provided as the final key answer. Next, yeah, even I find C is the correct answer, but for 59. But the key answer, as we have to go by that, some questions are doubtful in this question paper. Next, 60th question. If an offender is sentenced to imprisonment for a term not exceeding 6 months, solitary confinement shall not exceed A 15 days, B 1 month, C 2 months and D 45 days. Is it 72 or 73? 73 of IPC relates to solitary confinement. Hence, it is 1 month. There is a time limit. So, if imprisonment is not for exceeding 6 months, then solitary confinement shall not exceed 1 month. 61st question. Section 76 and Section 79 of IPC provide the general exception of A. Mistake of law, B. Mistake of fact, C. Both mistake of fact and law, and D. Either mistake of law or of fact. 76 is regarding mistake by a person who thinks he is bound by law, and Section 79 is mistake by a person who thinks that he is justified by law. That's why these are kind of mistake of fact. B is the correct answer. Yes, mistake of law is, of course, it's a no excuse. 62nd question. In a criminal trial relating to causing of injury on the body of victim, sole eyewitness deposed in accordance with prosecution case that accused inflicted a punctured wound with a sharp weapon. Post-mortem surgeon gave evidence that wound on the body was caused by gunshot. On the basis of this evidence, which among the following will be the most probable outcome? A. Court can convict the accused based on direct evidence of eyewitness. B. Court should discard opinion evidence and rely on direct evidence. C. Court should rely only on evidence of expert surgeon. D. Accused should be acquitted, granting benefit of doubt based on contradictory version of prosecution witness. The question is with respect to contradictory opinions of sole eyewitness and the medical witness, medical expert, doctor evidence. So, when such a thing is there, always actually the importance has to be given to the eyewitness statement, but completely the medical evidence also cannot be discarded. That's why granting benefit of doubt, accused should be acquitted based on the contradictory version of the prosecution witnesses. No, when always sole eyewitness opinion prevails, not opinion, eyewitnesses evidence prevails over the medical witness or the expert opinion. It is only an opinion, whereas witness has perceived the facts through his senses. That's why his evidence prevails. 63rd question. Accident as an exception has been dealt with in which among the following provisions of the IPC? A. Section 77, B. Section 78, C. Section 80 and D. Section 82. Accident as an exception. This is given under Section 80. C. Section 80. A very easy question. Next, 64th question. Which among the following statements is true in relation to examination in chief of a witness? Leading question can be asked. It must only relate to relevant facts. C. It must relate to facts in question, and D. All of the above. when a witness is being examined, that's examining chief is being done, then it must relate to only relevant facts. If it is a fact, it has to be fact in issue, not with respect to any general fact. Specifically, it has to be fact in issue. Otherwise, no. So they are saying evidence can be given only with respect to fact in issue or relevant fact. Because facts could be a very broad category. 65th question. The presumption that all judicial and official acts have been regularly performed can be drawn from which provision of Indian Evidence Act? A. Section 123, B. Section 114, C. Section 121, C. Section 112. Section 114 relates to presumption of certain facts. Okay, all other were presumption of law, but section 114 is with respect to presumption of facts. So that is one of the example given under section 114, that judicial and official acts have been regularly performed. 66. A disputed signature or handwriting of a person can be proved under section 67 of the Indian Evidence Act by which among the following method? A. By invoking section 73 of Indian Evidence Act. B. By direct oral evidence of a person who is conversant into the handwriting or signature of that person. C. By adducing the evidence of an expert. And D. All of the above. How do we prove the disputed handwriting of a person? It is D, under all these methods. Okay, different methods are there. 47, this is 47. Okay, next 67 question. To form an opinion under section 50 of Indian Evidence Act relating to relationship of one person with another, opinion of which among the following person is admissible? A. Any member of the family. B. Any person who has some knowledge about the relationship. C. Any member of family or otherwise who has special means of knowledge on subject. And D. All of the above. What is the answer here? With respect to section 50, if a person has to give opinion of a relationship, then he should be of a member of a family who has special means of knowledge on particular subject. So C is the correct answer. 68th question. Under the provisions of CRPC, cognizance is taken of. So how do we refer whether cognizance is taken of an offence, or cognizance of an accused is taken, or cognizance of final report is taken, or none of the above? Just do you mention as cognizance is taken? See, always cognizance is taken of an offence. Okay. Next 69th question. Regarding presumption about a document under section 90 of the Indian Evidence Act, which among the following is true? A. It should come from proper custody. B. It should be more than 30 years old. C. If conditions under section 90 are attracted, court can draw presumption regarding signature and handwriting. And D. All of the above. Let's come to presumption under section 90. Which of the above these are true? It is D. Yes, all of the above. From proper custody, 30 years old, it can draw presumption regarding signature and handwriting. Next 70th question. Under section 202 of CRPC, the magistrate is not authorized to A. Conduct enquiry himself. B. Ask police officer to conduct an investigation. C. Ask a person who is not a police officer to conduct an investigation. And D. Issue process to the accused. What the magistrate is not authorized to do under section 202. So this is the case where section 202 is with reference to postponement of issue. So that's why he cannot issue the process. So D is the correct answer. Issue process to the accused. 71 question. Laying of trap is a part of A. Inquiry. Okay, this is I. Inquiry, B is E. Inquiry, C. Trial, and D. Investigation. Yeah, it is the trap of an investigation. D. Then test identification parade is conducted as a part of A. Trial, B. Inquiry, C. Inquiry, and D. None of the above. 72nd question. This is test identification is the parade, is the part of the investigation. Hence, none of the above is the correct. Where investigation has not been given, that's why D, none of the above. Next, 73rd question. A, without any cause, fires a loaded pistol into a crowd. One person died of bullet injury on the spot. What, if any, is the offence committed by A? A. Murder. B. Culpable homicide not amounting to murder. C. No offence since he had no intention. D. Rash and negligent act endangering or safety of others. Okay, this comes under section 300, illustration. So that's why this is a case of a murder only. A. Next one, 74th question. To escape from criminal liability, when a defense of intoxication is set up, the intoxication should be A. Self-administered, B. Administered against his will or knowledge, C. Should not be self-administered, and D. All of the above. If he has to take the defense of intoxication, whether he should have administered the intoxication or he should not have been self-administered or against his will. B is the correct answer, section 85 of IPC. Administered against his will or knowledge. 75th question. The right of private defense is based on which among the following? A. Self-preservation, B. Self-respect, C. Self-sufficiency, and D. Self-reliance. That's the principle based on a very easy question, self-preservation. 76th question. Which among the following is correct in relation to distinction under section 34 and section 149 of IPC? A. Section 34 creates a specific offence, whereas section 149 does not. B. Section 34 as well as section 149 creates a specific offence. C. Section 149 creates a specific offence, whereas section 34 does not. And D. Section 34 as well as section 149 do not create specific offence. '76. Yes, C. It creates a specific offence, whereas section 34 does not create. 77th question. Cruelty under section 498A IPC does not include which among the following? So this question itself, the options, even I find it somehow vague, this one. The answer as is provided as D under final key answers. Okay. It includes all kind of cruelty. Yes, even I feel it so, but this question did not get deleted. It is not deleted, but somehow I find it somehow some word is missing or something. Maybe that's it should have covered. It includes this wouldn't have been there, I guess. Yes. Next 78th. Doctrine of voluntary non-fit injury is incorporated in A section 88 of IPC, B section 87 of IPC, C section 89 of IPC, and D all of the above. Voluntary non-fit injuria. It is yes. So section 88 is act done by consent in good faith. Consent in good faith. B is act intended not likely to cause death, and C is for the benefit of child, act done for the benefit of child. That's why all of the above. 79 question. Under Indian law of crimes, right of private defense is available with respect to A. Harm to body, harm to mobile property, C. Harm to immobile property, and D. all of the above. So it is available with respect to the defense of the person also and also the property. So property involves both mobile and immobile. That's why all of the above. Offense against body and offense against property. Next one, 80th question. In preparing the questions put to the accused under section 313 CRPC, the court can take assistance of whom among the following? A. Amicus curiae, B. the prosecutor, the accused, C. the prosecutor, and D. the prosecutor and the defense counsel. This is section 313. 13th statement. Here it can take the assistance of both the prosecutor and the defense counsel. So not only prosecutor, the provision got amended. So that's why even the defense counsel also can help in framing 313 statements, 313 questions. Okay, we have completed about 80 questions. 20 more questions are there. We'll complete them quickly. So many questions got deleted here. Okay, many questions are there. So see, 81st question. The principle of actus curiae neminem gravabit is incorporated in which provisions of the Code of Civil Procedure? A. Section 151, B. Section 152, C. Section 144, and D. Section 10. It means an act of judge, an act of court shall prejudice no one. So if a court has given a judgment, it should not affect anyone, right? So 152 is regarding amendment of the decree when some mistakes are there in decree, and 144 is with respect to restitution where the decree gets varied or reversed. A person who is entitled to get benefit, he can file the application for restitution. That's why even this is a case and this is also a case. Both the answers are correct. Both are based on the act of the court, but it should not affect anyone. Okay, both are correct, 151 and 144. The concept of letter rogatory is found in which among the following? A. Indian Penal Code, B. Code of Criminal Procedure, C. Law of Property, and D. Specific Relief Act. Letter rogatory means it is one of the concept found as CRPC, where for another country they will to obtain the assistance to take the evidence, they will send a letter of request. That's known as the letter rogatory. It's found in CRPC. 83rd, legality of narco analysis test was considered by Supreme Court in which among the following case? A. Selvi versus State of Karnataka, B. Kathi Kalu Oghad versus State of Bombay, C. Aruna Shanbag versus Union of India, and D. Indra Jaisingh versus Union of India. Yes, it's a very famous case regarding narco analysis test. It is A. Selvi versus State of Karnataka. 84th question. Who among the following was the first woman Chief Justice of a state? A. Srimati Anna Chandi, B. Srimati Leela Seth, C. Srimati Fatima Bibi, D. Srimati K.K. Usha. First woman Chief Justice of a state, not Chief Justice of India. If it was Chief Justice of India, it would be Justice Meera Sahib Fatima Bibi. But this is Chief Justice of a state, that's why Srimati Leela Seth. Okay. And next question, it got deleted. It's something very different. Questions is wrongly framed. Options are also. So let's not discuss this. Okay. This somehow different options are there. 86th question. Even this question got deleted. Here the principle of rarest of rare case was laid down by Supreme Court in. Provisional answer was given as Me Too versus State of Punjab, but ultimately even this question got deleted. I don't know the reason for that. Okay. Next 87 question. In a trial relating to murder of A. Yeah, originally it was Bachchan, but yeah, maybe because of a laid down for that reason, like from the beginning, that's why they might have stated that. Maybe, I don't know. Because this some other questions are there that were not deleted. Okay, let's leave it. Let's not discuss right now. 87th question. In a trial relating to murder of A, one witness deposed that few days prior to the death of A, the witness saw A and accused sitting in a bar and consuming liquor. He had not seen them thereafter. Which is the most reasonable and rational conclusion which court can draw? A last-seen theory can be applied. B. A and accused were friends and hence the accused could not have committed murder of A. C. No inference can be drawn from the version of witness. And D. A and accused were in good terms at least till few days prior to death of A. So we have to check whether the last seen theory is applying or not, because we have to see the facts. Few days prior to the death of A, a witness saw A and accused sitting in a bar. So does this amount to last seen theory or not? That's the question. So what can be concluded? It is D. Just they were sitting and having a drink in a bar. That does not mean that he was seen last together with that person. It just gives the conclusion that A and accused were in good terms at least till few days prior to death of A. Next 88th question. Fiduciary relationship is a relationship between two persons based on A. Trust, B. Contract, C. Blood relation and D. Money. What's the answer here? It is yes. Many times we say what is a fiduciary relationship. So it's based on trust. A. Next 89th question. A witness makes a statement in court knowing it to be false. He commits the offence of. What is the offence? Although knowing that if it's wrong. A. Perjury, B. Contempt of court, C. Forgery and D. None of the above. It is A. Perjury under section 193 APC. 90th question. What is an eo nomine party? The meaning of eo nomine party. A nominee of a party by or under that name. C. Not a nominee of a party. A party who is brought on record by orders of court. It is B, yes. We can say a purchaser has not been included as a your nominee party. So like that we can refer. Next to 91st question. A statute states that sale of a car, van, jeep and such other vehicles require license. The question arises whether for sale of two-wheelers license is required. Which rule of interpretation is to be employed? A literal interpretation, B golden rule of interpretation, C redendo, singular, singulis and D none of the above. It is none of the above because the rule of adjustem generis of the same kind and nature, that interpretation is applicable. Rule of adjustem generis. Hence none of the above. Okay. What is a court of record? Here two options could be possible. Okay, a court which preserves the records forever, a court whose judicial proceedings are covered by records, C a court which can punish for contempt, and D none of the above. Supreme Court is a court of record under Article 129. No, it is actually C, okay, and even A. Court for they say it preserves its record perpetually, like that also they say. Actually C is the correct answer. To some extent even A is correct. 93rd question. Who is the first Chief Justice of India? Patanjali Shastri, Harilal J. Kania, CMC Mahajan and D. B.K. Mukherjee. It is none other than Justice Harilal J. Kania, who happened to be the first Chief Justice of India. Next one, 94th question. If both offices of President and Vice President happen to be vacant simultaneously, who will discharge the duties of President? A Prime Minister, B. Speaker of Lok Sabha, C. Chairman of Rajya Sabha and D. Chief Justice of India. So when both of them are not there, then it is the Chief Justice of India who will discharge the duties of the President. 95th question. Fundamental duty is referred to in which part of the Constitution of India? A. Part 4A, B. Part 3, C. Part 4 and D. Part 5. Ninety-fifth question. It is fundamental duty which was added by way of an amendment. It is yes, Part 4A. Next, 96th question. In which case the Supreme Court allowed passive euthanasia in exceptional circumstances? A. Geeta Chopra versus Union of India, B. Aruna Shanbhag versus Union of India, C. Seema versus Ashwin Kumar and D. Minerva Mills versus Union of India. Partially, in exceptional circumstances, this was allowed in B. Aruna Shanbhag versus Union of India. Next, 96th, 7th question. What is the meaning of in pari delicto? A. Both parties in dispute are at fault. B. When parties dispute each other. C. Both sides are not at fault. And D. None of the above. In pari delicto. What is the meaning? It is both parties are at fault. 97th question. Then last three questions. 98th. In which case the Supreme Court of India directed compulsory registration of all marriages? A. Seema Shetty versus Union of India, B. Selvi versus State of Karnataka, C. Minerva Mills versus Union of India and D. Seema versus Ashwin Kumar. compulsory registration of the marriages? It is D. Seema versus Ashwin Kumar. And 99th question, this question got deleted, okay, where fundamental rights have primacy over directive principles. Our provisional answers gave this as the correct answer, Mineral Mills versus Union of India, 99th question. But ultimately this question got deleted. Next, 100th question, what is meant by a holographic will? A. Will in handwriting of the testator. B. Will kept in a mechanical device. C. Will in a printed form. And D. None of the above. What do you mean by holographic will? It is a will in the handwriting of the testator. Okay. So far we have completed about 100 questions. So tomorrow also we will be discussing 2020 question paper from 9 o'clock onwards, from 9 a.m., 9 p.m. Same like 1 hour, 1.5 hour duration. Let's discuss them in a like not a very quick manner also, not very detailed also. In this space, let's discuss them. Okay. So see you all tomorrow at the same timing. And my other classes we have about different batches are there, as you all know. So see, this is a new batch which is going to start. Before that, I want to mention all about free All India Judiciary Scholarship Test, which is going to be conducted on March 5th at 12 p.m. So you can scan this QR code to enroll into this. And tomorrow is the last day for the offer for 20% off on judiciary subscriptions. If you want to purchase, you can use my code Aparna Law for availing this benefits. For Judiciary 2023, you will have to pay rupees 36,736, and for Judiciary 2024, you are supposed to pay 50,511 in this offer period. Otherwise, you would end up paying 20% more. Now, flat 20% discount is there on this. And different batches are there. Safalta 4.0 comprehensive batch, which is for duration of 12 months for 50,511, and linking batch for RJS and Gujarat Judicial Service. This is for 36,736 and for 6 months. And Uttar Pradesh mains examinations 3 months batch, which is for 22,959. And you may be knowing we have different mock test series which are being launched. This is only for rupees 500. Okay. So this is the test schedule. About 5 tests are given, 5 mock tests are there, 5 full length mock tests are there. And main test series for Punjab Judiciary, which is 3 mock tests will be conducted in this, which is for price of 4,999 only. And mains test series for Uttar Pradesh Judiciary 2023 is there. Even this is for 3 mock tests are there. This is available only for 100 subscribers, where 2,999 rupees offer price is available. Okay. So this was all about our mains test series and different kinds of test series which we can avail. So thank you all of you for joining, and tomorrow we will be dealing with the 2020 question paper. Today how we dealt with the 2022. Likewise, Kerala 2020 question paper analysis will be done at the same timing, 9 o'clock. And even my special classes are there tomorrow at 10 a.m. on Unacademy platform on order 22 to order 30. So do join that link. Do join the class for participating in a poll where I'll be conducting the poll. Okay. So thank you all of you. Take care. Bye bye. Good night all of you.